Welcome to INN's Advocate. INN's Advocate is a platform for lawyers having less than 5 years of practice. Today we have with us Advocate Utsav Rajeshbhai Doshi. He has graduated his law from New Law College in the year 2019. He is currently pursuing LLM in business law. He is also pursuing company secretary course. Advocate Utsav practices in civil law, property law, society law. He also undertakes work in non-litigation area and deemed conveyance. Today he is going to speak on companies, compromises, arrangements and amalgamation. So without wasting further time, I would request Advocate Utsav to commence with his lecture. Thank you.
First of all, thank you Advocate Nikhil for having me here and giving me such opportunity for this lecture. So today we are going to start with companies, compromises, arrangements and amalgamations. So basically it is covered under chapter 15 of the Companies Act 2013. But before going to this chapter, we should know at least how it come, when it come and why it come. So first question, it came in 2013 only in Companies Act 2013. Before it was there or not? So answer is yes. Before 2013 there was an act, Companies Act 1956, where companies, compromises, arrangement and amalgamation provision was there. Under section 391 to 396 it was covered. But what was the reason why it came to 2013? Is there any changes in 2013 or not? So the answer is positive once again, because in 1956 Act there was the economic condition and everything was totally different. For company the survival was totally different. So there was the provision of companies, compromises, arrangement and amalgamations. But after 2013 the new act came, 2013 Act, and in which most of the provisions of the companies, compromises, arrangement and amalgamation was enacted. And after the Companies Act 1956, in Companies Act 2013, the provision of the companies, compromises, arrangement and amalgamation Act was covered under section 230 to 240, which we'll cover in this lecture obviously. So if there was a provision in 1956, so why it is changed and why it is covered under 2013 Act? So in the Companies 1956 Act, the scenario of the companies was totally different. Scenario of economic condition was totally different, and in 2013 there was a huge difference as per the market condition of 1956 and 2013. So it is necessary to change the companies, compromises, arrangement and amalgamations provision. So let's begin with the terminology of compromises, arrangement and amalgamation. Are they same or they are different? So compromises is different, arrangement is different and amalgamation is totally different. Amalgamation is what it includes: mergers, acquisition, demerger and everything. Compromises is in which company compromises, or we can say that they come to an agreement with the creditors or the members, and in arrangement they come to the arrangement with another company or their shareholders, their member, or they just change their capital structure and everything. So if we see this significance of the compromises, arrangement, amalgamation, so it facilitates corporate restructuring. So what is corporate restructuring? Corporate restructuring is of many types, but many a time it is organic growth for its organic growth and inorganic way. So first promotes financial stability. So amalgamation promotes financial stability. How it promotes financial stability? When the company is financial distressed condition, so another company who take over the company or merges with the financial distressed company, and it start with the its day-to-day activity with its own funds. So it will reduce the funds need in the financial distressed company, and hence business synergy. Synergy of the business is always increasing when mergers or demergers, mergers or acquisition happens. It never be 1 plus 1 equals to 2. It will always be 1 plus 1 equal to more than 2 because of its synergy gain. And stakeholder protection. What is in compromise arrangement amalgamation? When two companies are making compromises with its creditors or members, or it is making arrangements, or it is making amalgamation by way of merger or acquisition, in which the parties are involved in this process are creditors, sometimes it is shareholders and other stakeholders like government and other shareholders and everyone. So are their protections are their interests are protected under companies compromises arrangement amalgamations or not? So our answer is once again positive. The interest of all the stakeholders are protected, and as the procedure of the compromises arrangement amalgamation is in such a way that the protection interest of the all the stakeholders are protected in its way. We will discuss in further in this lecture only. So the main function of the compromise arrangement amalgamation is judicial oversight. This process is done in judicial oversight only, not other than this. Not other than this. So efficiency in process. The process is done efficiently because it involves judicial oversight. Encourage negotiation and collaboration. When company merges with another company, it encourages negotiations and it also encourages collaboration. Modernization of legal framework. In Companies Act 1956, there was no special tribunal or something for this matter, and in 2013 Act, the National Company Law Tribunal was started, incorporated, and all the matters relating to compromise arrangement amalgamation was heard before the National Company Law Tribunal. Empowers minority shareholders. The Companies Act 2013 provides minority interest of minority shareholder, even if the by way of case law, leading case law First versus Arbuckle, in which the interest of the minority shareholder was protected, and there was many exception was given. Contribution to the economic growth. When the company company is growing, it also contribute to the our Indian economy. So it also contribute to economical growth. So first question arise in our mind is why this why this corporate restructuring? So sometimes company is in need of financial support, funds are not enough to run the company. In this situation, corporate restructuring plays a major role, and at that time financial distress company are taken over by the company who is in who is with well reserves and having much funds than the distressed company. And also it is also provide that the company which is in profit is acquiring the financial distress company or loss making company, they will get the taxation benefit. So it is beneficial for both the companies who is making the profit and who is making the losses also. Strategic realignment, in which the company is not having company is having the strategy, or another company which is having the funds, or sometimes the company is in the market where the strategy is needed but it is not having the strategy, it is located outside the India, and they can also merge and do the strategic realignment. After that, it provides growth opportunities. When more than two companies come together, they provides company resources, capabilities, and market access to enhance growth. Thereafter it provides stakeholder protection. Who are covered under the stakeholders? Stakeholders covers creditors. Once the process of compromise arrangement amalgamation started, it provides that the meeting of the creditors is compulsory, and the majority of the creditors shall approve the process of compromise arrangement amalgamation. In such case, protection of the creditors are intact. Thereafter, shareholders meeting of the shareholder is compulsory to pass the resolution. After that only you can file the application to the tribunal for the purpose of compromise arrangement amalgamation. Employees, it also provides the provision which provides that when two or more companies are merging, in such case the employee is in some post is in the post of managerial condition, then after the merger he cannot be provided the any position below the managerial position. He shall be provided with the managerial position or above that position. The company cannot degrade the position of the employee. After that, regulatory oversight and judicial authority. As I said, in the Companies Act 1956, there was no tribunal, there were court, and the court proceedings are very lengthy and it takes much more time than the tribunal. So in 2013, National Company Law Tribunal was incorporated, and thereafter all the matters related to compromise, arrangement and amalgamation was shifted to the National Company Law Tribunal. Even the new matters related to compromise or arrangement amalgamation is filed at the National Company Law Tribunal. And compromise, arrangement, amalgamation will never be done without the interference of the National Company Law Tribunal, which is making it more secure and safer. Thereafter, flexibility and efficiency. Chapter 15 of the Companies Act 2013 designed to flexibilities of companies, that in earlier provision in 1956 the flexibility was not there. You have to go through the procedure of court and do everything as per the direction of the court, which was not providing any flexibilities to companies. But however, after 2013 Act, you have to apply to the application to the tribunal, and tribunal provides the direction to conduct the meeting with the creditors and other members who are affected by such compromises or arrangement or amalgamation, and they provide a streamlined process. There were no multiple processes, there was streamlined process, and you have to follow the process as per given in the process. Key aspects of the compromise includes negotiation, mutual agreement and legal framework. In negotiation, it generally includes when the compromise is happening, it's just because of the financial distress condition. So if a company wants to overcome the financial distress condition, they generally reschedule the repayment, and they change the tenure of the repayment, or by extending the tenure of the repayment. Thereafter, mutual agreement, when creditors and organization do not agree on mutually, then the compromise is not possible. Legal framework, also it will covered under it will go to the National Company Law Tribunal only. So thereafter compromise, it comes to arrangements. So what is arrangement? Arrangement is changes made within the organization for some operational changes or some other changes. So what kind of changes come arrangement? What kind of changes may be incurred in arrangement? Arrangement may involve merger, demerger, transfer of shares, or changes in right of different classes of shareholders. Scheme of arrangement. What are the type of scheme of arrangement? This is specific type of arrangement that outlines the detailed terms agreed upon the companies and its stakeholder, which must also approved by the NCLT. So in order to do the arrangement in the organization itself, it has to get the approval by the NCLT. Stakeholders involvement is necessary when the interest of the stakeholder are involved in the arrangements. Key aspects of the arrangement. Types of arrangement, as I told earlier, mergers or amalgamation, when two or more companies are coming together and forming a new entity, is a merger or amalgamation. It can also demerge the company. If a company is making company is having multiple departments, but one of the department is making continuous losses, so company can demerge the particular department from the company. Changes in share capital, it can increase the share capital, decrease the share capital, or it can split the share capital. Modification of rights, changing the rights attached to the different class of shares. What are the legal process involved in compromise, arrangement, amalgamation? In compromise, arrangement, amalgamation, you have to file the application to the tribunal, and then after conduct a meeting as per the direction of the tribunal, and once the plan is approved by the creditors members, then it goes to National Company Law Tribunal, and thereafter National Company Law Tribunal, that is also called as NCLT. NCLT shall interfere in the process of the compromise, arrangement and amalgamation, and NCLT shall ensure that the process is done with the done in the fair and reasonable manner and transparent manner, and it complies with the provision of the Companies Act 2013. This include ensuring that the proper procedure were followed and obtained proper approval from the board, shareholders and creditors. Stakeholder involvement is necessary in this process. and the protection of minority shareholder interest is also provided in this compromises, arrangements and amalgamation, by ensuring that they are not unfairly disadvantaged in the arrangement process, that majority shareholders sometimes take disadvantage of their majority. So, protection to the minorities are provided in this process. Compromises refer specifically to the agreements between the company and its creditors or member about the terms of debt repayment or obligation. Its main purpose is to resolve financial issues. However, arrangement is a broader term that includes compromise, encompass various forms of corporate restructuring such as merger, demergers, changes in capital structure. It involves formal schemes that can affect the company's overall structure and operation. That means it aims at operational challenges and restructuring of capital. Whereas amalgamation is amalgamation is an arrangement that involves merger of two or more companies in a single entity. This process typically aims at combination of resource, involve efficiency and create a stronger market presence. Legal process is already covered under this chapter, where the meeting of the creditor stakeholder is to be taken, and then after file it with the NCLT and process with the. And one question arises in this is whether the compromises, arrangement and amalgamation are interdependent or not. So, we can say that compromise can be essential component of an arrangement, particularly in situation where a company is restructuring its debt as a part of merger or acquisition. Amalgamation might involve comprehensive of arrangements. However, it does not include compromise. That includes with the creditors ensuring that the financial obligations are merged during the transition. Now, going to the legal aspects of the compromises, arrangement and amalgamation. Chapter 15 of the Companies Act 2013 involves section 230 to 240. So, what does these sections provided for? Section 230 is provided where power of the tribunal to compromises arrangement is provided. So, section 230 empowers the tribunal to make the compromises and arrangement or to facilitate the compromises and arrangement between the company and its creditors and member. When the company is in financial distressed condition, it provides the NCLT to make compromises between the companies and its creditors or member. Section 231 provides, I told some various times that application to the tribunal is to be done, application to the tribunal is to be made. So, particular section which should be provide that the how to file an application and where to file application. So, section 231 provides that application to the tribunal is to be made. Specify the procedure. Section 231 specify the procedure for submitting an application to the tribunal for approval of the compromise and arrangement. This application must include proposed scheme and necessary details. If you are filing without the proposed plan or scheme, the application should not be maintainable at the NCLT. Section 232 provides for merger and amalgamation of the company. This section governs the process of the compromise arrangement amalgamation, detailing the procedure of merging of the company, including both domestic and foreign company. In the earlier law 1956, there were no provision for merging of Indian company with the foreign company. That's why it is beneficial where under 2013 where Indian company and foreign company can merge together. It emphasizes that need of the NCLT approval and the protection of the right of shareholder, that when the NCLT comes to the picture, it will always follow the procedure and it will protect the interest of all the stakeholders. Section 232 provides for the amalgamation between two or more small companies, two or more wholly owned subsidiary company, two or more startup company, or one startup company with another small company. It is also called as fast track merger, where the procedure of the merger is simplified and in which the stringent provision of NCLT is much reduced. However, it needs to satisfy some criteria. Criterias like 90% of the shareholders approval are taken, 19th of the creditors are approved for the said merger. Section 234 provide for merger of the foreign company. It outlines the framework of the merger of an Indian company with the foreign company. This section includes provision complies with foreign exchange regulation and the approval process. So basically, under 234 section, we need to follow the section 232, that is merger and amalgamation of the companies. The additional part in this section 234 is it involves foreign company, and when the foreign company involves, it also includes the FEMA provision and also the RBI guidelines. So we need to comply with the RBI guidelines and FEMA provision in order to merge with the foreign company. Section 235 provides that power of a tribunal to order for the compromise. When the tribunal is satisfied that all the procedures are complied with the provision of the section Companies Act 2013, then and there is no unfair practices or it is fairly provided in the scheme, everything is fairly provided in the scheme. In such situation, the tribunal can order for the compromises. Section 236 provide for purchase of minority shareholders. When the majority of shareholders are in favor of the compromises or arrangement, in such situation where the minority shareholders are not in favor and they are suppressed with the majority of the shareholder, in such case tribunal orders the company to acquire all the shares of the minority in order to protect the interest of the minority. Section 237 provides that central government have power to make a compromise where it is in the interest of the national, where it is in national interest. Central government can provide compromises between two or more company, and when the central government provide for the compromise or arrangement, you cannot challenge the compromises of such companies. Section 238. Section 238 is providing for the registration of the scheme. When the scheme is approved by the NCLT, it has to register with the registrar of for the purpose of the compromise or arrangement or amalgamation. Section 239 provides for the power of inspector to carry out the inspection. When we say that NCLT is providing for the meeting of the creditors, meeting of the stakeholder, in such case who will ensure that the meetings are conducted in the proper manner or not, and in such situation section 239 is provided, where the inspector can carry out the inspection and provide that all the procedure relating to compromise, arrangement, amalgamation as provided under section 230 to 240 of the Companies Act 2013 are done with the proper manner or not. So the inspector can carry out the inspection. After that, section 240 provides the consequences of compromise and arrangement, where the compromise or arrangement is done and compromise is made in order to do any fraudulent transaction or to do fraud with the stakeholders or creditors or other shareholders or other stakeholder. In such situation, the person or the entity who is doing fraud, they are still liable after the merger or amalgamation or compromises or arrangement. They cannot say that the company is wind up or the company is now merged with some another company, so we are not liable for the act. They will still be liable for the same act they done before the merger or amalgamation. So procedure for initiation of compromise arrangement, I discussed earlier that the filing of the application with the tribunal, companies must prepare detailed application to be filed with NCLT. The application typically includes a copy of proposed scheme or arrangement, financial statement and reports, detail of meeting held with creditors and stakeholder if applicable, and some other documents which is necessary in the eyes of the NCLT. Meeting required for the creditor and shareholders. Once the approval from the creditor is taken by the company, the meeting of the shareholders is to be done and the approval of the shareholder is necessary. After that, what is the role of NCLT? NCLT's role is as under. After reviewing the application of the approval obtained from the creditor and shareholder, NCLT will hold the hearing. If satisfied that the scheme is fair and complies with law, the tribunal will approve the compromise or arrangement, making it binding to the all parties. And once the scheme is approved by the NCLT, it will be binding on all the parties. So function and powers of the NCLTs are as under. Approval of the compromise or arrangement. Once the NCLT is satisfied with the condition, they will approve or reject the scheme as per the NCLT's view. It evaluates whether the terms and proposal are fair, reasonable, and in the interest of all stakeholders. If the terms and conditions provided under the scheme is not favorable, is not fair and reasonable to the stakeholder, it can reject the application. Hearing the application. Once the application is approved, NCLT will conduct the conduct an hearing where seeking the approval of the compromise arrangement. During this hearing, the NCLT reviews documentation, hear representation from stakeholder, and consider objection if any. Regulation in a meeting. NCLT can order meeting of the creditor and stakeholder to discuss and vote the proposed arrangement. It ensures that proper procedure are followed during these meetings, including the fairness of the voting process. Binding effect. Once approved by the NCLT, the compromise or arrangement becomes binding on its company and all the stakeholders, including dissenting creditors and shareholders. The binding nature is crucial for ensuring compliance and facilitating smooth implementation. Dispute resolution. The NCLT can resolve disputes that arise during the compromise arrangement process, providing legal framework for conflicting resolution. This enhances trust and confidential among the stakeholders. So, monitoring compliance. NCLT has power to monitor compliance with the approved scheme, ensuring that the company adhere the terms and conditions as set forth in the arrangements. Ensuring fairness. The involvement of the NCLT introduces an essential layer of the judicial oversight, ensuring that all the compromises and arrangements are conducted fairly and transparently. The tribunal assesses whether the interest of minority shareholder and creditors are adequately protected. Legal validity. The approval of the process conducted by the NCLT leads to legal validity to the compromises and arrangement. Without such approval, arrangement might be challenged in court or deemed unenforceable. Protection of stakeholder interest. The NCLT acts as a guardian of a stakeholder interest, providing a platform for the creditor, shareholder, and other affected parties to voice their concern and objection. The oversight helps prevent potential abuses of power by majority of shareholder or management, facilitating corporate stability. By providing structured process for approval, NCLT helps facilitate corporate stability during the restructuring, allowing the companies to navigate financial difficulties while maintaining stakeholders' trust. Transparency and accountability. The requirement for judicial approval promotes transparency in the restructuring process. Companies must present their proposal clearly and justify the rationale behind them. This accountability is essential in maintaining the integrity of corporate governance. Now moving forward to the next part, that protection of the creditors. How the protection of the creditors are maintained. So first point is right to participate. When the creditors are provided with the right to participate in the meeting and to vote in the meeting, their protection are intact and they are protected by the right to vote in the agreement. Majority approval requirement. When the scheme is proposed, it cannot be the application for such scheme cannot be filed to the tribunal unless and until the majority approval is gained from the creditors. After the judicial security, the NCLT reviews the term and compromises to ensure they are fair and reasonable. This security helps protect the creditors from potential oppressive terms proposed by the company. Transparency in information. Companies are required to provide creditor with adequate information about the financial position and implication of the proposed compromise. The transparency allows creditor to make informed decision. How they protect the shareholders. So they also provide the voting rights to the shareholders. Shareholders are entitled to vote on the proposed arrangement. The requirement of majority shareholders approval ensures that significant decisions reflect the interest of the shareholders. So class meeting. It is the main provision where the meeting of the shareholders is to be taken as per the class. That act allows the separate meeting for different classes of shareholders. That is, if they are if the interest of preference shareholder are preference shareholder are in stake, then preference shareholders meeting is to be conducted, and when the interest of the equity shareholders are intact, in case equity shareholders meeting are to be taken. Protection of the minority interest. Minority shareholders are not unfairly prejudiced in the restructuring process is to be ensured. The arrangement must be fair and not disproportionately disadvantage the minority shareholders. Detailed scheme disclosure. The scheme should be disclosed in very detail, and all the terms and conditions relating to the scheme should be disclosed, enabling the shareholder to understand how their rights may be affected and the potential benefits and the drawback is to be ensured. Apart from the creditors and shareholders, the protection of the employees is necessary. Impact assessment. Companies are required to assess the impact of compromise arrangement on employees. This includes considering potential job loss, changes in roles, and or alteration in employment contracts. Consultation process. Employees and their representatives may consult during the restructuring process. This engagement ensures their voices are heard, particularly concerning job security and working condition. Legal safeguard. Employee rights are protected. Their various labor laws and any arrangement that adversely affect the employment must comply with this law, providing additional layer of protection. What are the significance of this fair treatment in the restructuring process? So it promotes the trust and confidentiality. Fair treatment of the stakeholder fosters trust in the restructuring process. When stakeholders feels that their interests are respected, they are more likely to support the proposed arrangement. Reduced conflicts. When the ensuring fairness minimizes disputes and conflicts among the stakeholder, leading to smoother negotiation and implementation of compromises and arrangement. Long-term viability. Companies that prioritize stakeholder protection are more likely to achieve sustainable restructuring outcome by addressing the concerned creditor, shareholders and employees. Companies can stabilize their operations and enhance long-term viability. Encourage participation. When stakeholder believes that their rights will be protected, they are more inclined to engage in the restructuring process. This active participation can lead to more innovative solution and collaborative approach. Legal and ethical compliance. Fair treatment aligns with legal obligation and ethical standard, reinforcing in integrity of corporate governance. Companies that adhere to this principle are better positioned to navigate regulatory scrutiny. Now moving forward to the next part, that includes the case studies. So when it comes to the companies and industries, how we can forget the legendary person, that is Ratan Tata sir. So our first case is related to Ratan Tata sir company, Tata Steel. So in Tata Steel company and Bhushan Steel company, when in 2018 Tata Steel acquired Bhushan Steel, one of the India's leading steel manufacturer, as a part of insolvency and bankruptcy court process. Bhushan Steel was facing several financial difficulties and had debt exceeding 56,000 crores of rupees. Process. Whether Tata Steel submitted the resolution plan to the National Company Law Tribunal, which involves a significant compromises and on the debt owned by the Bhushan Steel. The proposed includes restructuring of company's financial obligation and investigation in operational improvement. So what was the outcome of this case? That NCLT approves the amalgamation, allowing Tata Steel to acquire Bhushan Steel, leading to increase in operational efficiency and enhance market position. The deal happened Bhushan Steel restrained in operational workforce and ensure creditors recoveries. So the outcome of this case law is synergy creation. Amalgamation can create synergies that enhance operational efficiency and market competitiveness. Stakeholder engagement. Engaging with stakeholder early in the process can lead smoother negotiation and better outcomes. Regulatory support, where the involvement of the NCLT provides necessary oversight, ensuring that the interest of all stakeholders were considered. Next case law is related to Jetway restructuring. In 2019, Jetway, one of the biggest and largest airlines, faced several financial challenges leading to its grounding on 2019. The company owed over 8,500 crores to creditors, employees and lessors. So process. The resolution plan includes scheme of arrangement that proposed significant compromises with creditors, including deferred payment and equity conversion. The NCLT was involved in approving the plan, ensuring that all legal and procedural requirements were met. The outcome of the case was the proposed restructuring was complex and faced various challenges, including regulatory hurdle and opposition from some stakeholders. So I told that without the approval of the stakeholder, the process cannot be go further. So in this case law, the ultimately the plan did not succeed in reviving the Jet Airways, and the airline went into liquidation. However, it is now in appeal in Supreme Court right now, so we cannot say further about that. But what lessons we learned from this case law is feasibility of plan. The plan should be feasible and it should not be complex in nature. In holistic approach, the comprehensive approach consider market condition, operational efficiency and stakeholder concerned crucial and successful restructuring. Adaptability, companies must willing to adapt their plans and in response to stakeholder feedback and changing circumstances. If the stakeholder are suggesting something, the company should accept the suggestions. Thereafter, Dhanuka Agritech Limited and Tina Rubber and Infrastructure Limited, in which Dhanuka Agritech Limited proposed a scheme of arrangement to acquire Tina Rubber and Infrastructure Limited, which faced financial difficulties. The process, the company sought approval from the NCLT for the merger, which involved compromise related to shareholder and debt obligation. Stakeholders were consulted and meetings were held to secure the necessary approval. The outcome of the case is NCLT approves the merger allowing Dhanuka to acquire Tina Rubbers, thereby enhancing Dhanuka's production portfolio in the market share. The arrangement also provides for Tina with the necessary capital and operational support to stabilize its business. So, lesson learned in this case law is strategic acquisition. Strategic merger can provide companies with the access to the new market and resource aiding in the growth. Clear communication is effective communication with the stakeholder about the benefits of the merger can help secure approval of minimize resistance. And regulatory compliance, adhering to regulatory compliance is crucial for ensuring that the merger process is smoothly and legally valid. General implication and takeaways of this compromise arrangement amalgamation is stakeholders engagement is crucial and critical. If the stakeholder are approving the meeting and approving the scheme, then only you can move forward to the application to the NCLT. Realistic plan matter. If you are providing plan which is not realistic and the stakeholder is not believing the plan, in such situation the plan will not be approved by the stakeholder and you cannot move further to the NCLT. Judicial oversight is essential. As told earlier that without the interference of the NCLT, the plan can go wrong anytime at anywhere. So, the judicial oversight is essential. The role of NCLT in reviewing, approving proposal, ensuring fairness and compliance, protecting the interest of all the parties. Flexibility and adaptability, as discussed in the earlier case law of the Jet Airways, where stakeholders do not approve the plan due to its complexity and the compromise arrangement was failed. So, it is necessary to be flexible and take the suggestion from the stakeholder before providing for the scheme, and they learning from the failures. They are analyzing unsuccessful cases provide valuable insights into the pitfalls and avoids the future restructuring efforts, emphasizing the importance throughout the planning and execution. So, this is not all which I have covered. This is just a tip of the iceberg. So, we can provide in another lecture. So, thank you for joining me today. If you found this video helpful, so do like and comment in this lecture, and any other any other topic on which you need lecture, so you can comment on that. Thank you so much. Thank you.
So Utsav, thank you very much. Your topic name is big, so I need to read it from here. It's companies, compromises, arrangements and amalgamations.
Yes.
It was nice that you have covered basically the entire functioning of a company, like amalgamation, arrangements, compromises. So it was nice hearing to you. Thank you for being our guest, and this is a small token from Hammurabi to you.
Thank you, Rahul sir. Thank you so much for giving us platform like this so that we can share our ideas.
Yes, yes.
Thank you so much.
Most welcome.